Hello and welcome back. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on legacy, property, trusts, estate planning, and everything else on my clients' minds. This is an episode about what to do with an irrevocable trust. I get this question a lot. That is, people comment on this issue a lot. And as we'll see in the next few minutes, what I would hope is that my clients would ask me about this before they do anything. That is, I hope they would look before they leap. We'll get to that. So here's the question they ask. Should we terminate this unwanted or unneeded trust? That's a great question. I'm glad they're at least considering that. But let's break that down a little bit. First, we're talking about a specific kind of trust, an irrevocable trust, a trust that was set up by somebody else for this individual's benefit. We've also talked on these episodes about revocable trusts. That's something different. That's a trust that someone can amend and revoke during their lifetime. Those are actually very easy to amend or revoke or terminate. We're not talking about those. We're talking about this irrevocable trust that was set up. But notice that this question is loaded. They're asking about an unwanted or unneeded trust. They're already assuming it's unwanted or unneeded. So I asked the question, what is it that could make a trust or unwanted or unneeded? Well, I often like to talk about the benefits of a trust, and we talk about that a lot on this podcast. Just a few of the benefits of an irrevocable trust. It can provide asset protection. We've talked about that if assets are in a trust, as long as the trust has certain language and provisions, then the assets of that trust are protected from the creditors of a beneficiary. Whereas if the beneficiary has those assets, the beneficiary's creditors could pursue those assets. An irrevocable trust also can provide a layer of asset management. Depending on who's in charge of investments and distributions, the trust can provide that layer of help to the parties to make sure the assets are used in the right ways. There are also tax implications here. An irrevocable trust can provide for the avoidance of estate tax at a beneficiary's death. It can also provide for the avoidance or reduction of another tax we talk about on this podcast called the generation skipping transfer tax. I think there's also various psychological benefits of assets held in a trust, and a lot of clients like this as they set up trusts. The idea being that these funds, this pot of money, is separate from the individual's own money. Maybe these assets are designed for further generations or for certain purposes the family values, like education. But we can also think about the costs or disadvantages of a trust. We talk about that on this podcast a lot too. There are some ongoing administrative expenses of a trust, especially if there's a third-party trustee. We've talked before about the income tax rates for a trust and how, depending on how the trust is taxed, there could be a higher marginal income tax rate for assets in the trust. Also, upon a beneficiary's death, typically the assets in an irrevocable trust would not receive any step up in basis for income tax purposes at that beneficiary's death. And one other cost or disadvantage of a trust we talk about are the psychological effects. Now, I talked about psychological effects as a benefit, but a lot of clients also think about the negative psychological effects of assets held in a trust. And a lot of clients are concerned that assets in a trust might actually interfere with a beneficiary's agency or sense of ownership or control over some of these assets. So here we have some benefits and advantages of a trust, or some costs, some disadvantages of a trust. And based on all of those together, in many cases, the family or the interested parties feel that the costs outweigh the benefits. And that's what I think when clients come to this conclusion that the trust is now unwanted or unneeded. A couple of examples of trusts that clients often find are now unwanted or unneeded. Maybe the trust was set up for a very young beneficiary, or maybe it was set up for a beneficiary before that beneficiary was even born. And now circumstances have changed, and now the costs might outweigh the benefits. Maybe it's a really good change of circumstances, like the beneficiary is now grown and responsible and could manage the assets his or herself. It could be a trust that is now relatively small in value. We sometimes call those an uneconomical trust, where maybe the size of the assets doesn't justify these other benefits that might otherwise be available. It could be that there are changes to circumstances, especially changes to tax circumstances. Maybe the trust was established years ago when estate tax was a really key issue. But as we talk about in this podcast, over the years, the estate tax exemption has gone up and up. And now estate tax is not as central an issue to much of this estate planning. So maybe, again, the costs don't justify any potential estate tax benefits that might have been in place when the trust was set up. Or it could also be that the beneficiaries would just prefer to have the money now. Lots of beneficiaries feel that way, and that might be a reason why they would want to just terminate this trust and distribute the assets to the beneficiaries. So let's talk first about how to terminate a trust. There's actually various methods, and the law provides certain procedures. One method could be that all the interested parties could get together and agree to terminate the trust. They'd also want to agree where the assets should go, maybe to which beneficiaries and in what proportions. Aside from an agreement by the parties, it could be that the trust is terminated by the sole action of the trustee. We've talked before that trustees often have the discretion to make large distributions to beneficiaries. Maybe the trustee could make a large distribution to one or more beneficiaries, thereby terminating the trust. The trust agreement could also include some provisions for a third party who has the power to just terminate the trust. We sometimes call that a trust protector or trust advisor or an independent trustee. They might have the specific power to terminate a trust. A beneficiary could also have a power over a trust. We've talked about that on a prior episode. They could have a power called a power of appointment, where the beneficiary is able to distribute the assets to others and just terminate a trust. As a little prelude, we'll talk about some pitfalls, but we especially want to be careful about beneficiaries exercising that kind of lifetime power of appointment. There could be important gift tax implications to that exercise. And lastly, and this is the one people often try to avoid, the trust could be terminated by court action. You could actually petition a local court, and as long as you meet certain requirements, the court can order the trust to be terminated. So we think about these two ends of the spectrum. We like to talk about spectra here on this podcast. One end of the spectrum might be agreement by the parties, could be very informal. Other end of the spectrum might be that court action, that court petition, much more formal. A lot of clients focus on the disadvantages of court action. We can think about that. It could be the cost of lawyers and other proceedings. Often takes a longer time to have that go through the court system. When you file something with court, it's typically made public, and it's also pretty formal. And some people even feel like it's pretty adversarial when you go to court. Meanwhile, a lot of parties like the idea, the simplicity of just agreeing among themselves. But we'll talk about some advantages and pitfalls of each of those approaches. So it's easy for a lot of parties to not want to proceed with court action because of these disadvantages. But court action can also have a lot of advantages. Importantly, if a court approves of this, then we get a formal judicial approval of these actions. And as we'll flag later, that could cut off parties from later challenging or suing about what was done to terminate the trust. There are also important tax implications to this. If there's an action by a judge and not by interested parties, then that can have advantages for gift tax and income tax and estate tax. And in fact, that's another reason why it might be best if the trustee acts to terminate the trust, because again, the trustee acting could avoid some adverse gift and estate and income tax implications if the parties act. So let's think about those tax considerations for a moment. A lot of clients would like to just terminate the trust. Again, they like that idea of simplicity, as simple as possible. But before terminating the trust, we want to think about these potentially adverse tax implications. Number one, let's think about income tax. I hope you've already thought about income tax for the trust. As I mentioned before, marginal rates for income tax could be a reason why the parties want to terminate the trust to begin with. So hopefully you've done a good analysis that that really is a cost that could be solved. But as you're terminating the trust, you want to make sure that that termination itself does not trigger income tax. It's not a realization event for income tax purposes. And your tax advisor and attorney can help you navigate some of those issues. We also want to think about the potential adverse estate tax implications to terminating the trust. I mentioned before that one advantage of an irrevocable trust is it can be structured so that those assets don't trigger estate tax at a beneficiary's death. And right now, the estate tax exemption being so high, a lot of parties feel that estate tax isn't really an issue they need to plan for. But if those assets go out of the trust to beneficiaries, then typically they would trigger estate tax at the beneficiary's later death. We hope that will be a long, long time from now, but who knows? Tax laws might have changed, and we'd hate to have a scenario where estate tax is due at that beneficiary's death, whereas if the assets had been held in the trust, that estate tax could have been avoided. There are also potential gift tax issues to the termination of a trust, and especially if beneficiaries are involved. A lot of clients are surprised about the potential gift tax issues here, but the IRS has been clear in various cases that there are potential gift tax issues, especially if beneficiaries participate in the modification or termination of a trust. And there was a recent chief counsel advice, the full citation will be in the notes in the transcript, where parties modified a trust with the beneficiary's consent to change a particular administrative position. And the IRS took the position that because some beneficiaries were giving up rights and the settlor was actually getting a benefit, that the IRS would treat this like the beneficiaries had made a gift back to the settlor. That could have really adverse gift tax issues for all the parties involved. And then lastly, maybe you're not surprised, I'm going to mention generation skipping transfer tax, GST tax. There are very complicated rules and regulations about modification or termination of a trust that has potential GST tax implications. So as you're considering modifying or terminating a trust, we always want to be mindful of GST tax. We'd hate to have a scenario where the trust is terminated, but the IRS takes the position that assets have shifted to further generations, and now GST tax is due, which can be really punitive. So as you're going through this process of considering whether to terminate a trust, I think it's important to document all these decisions. That'll help the trustee really evaluate whether this is the best option for all involved, show their work, show their reasoning. And that also ties into another important feature, which is communication. I always think it's important to communicate all these risks to the parties and maybe show the beneficiaries the potential tax advantages or disadvantages of one course or another, so no one can later argue that they didn't understand some of the risks of terminating this trust. You might also consider having the beneficiaries approve of the termination, although again, that could have adverse tax implications. So that's something that the legal advisor should really carefully weigh in on. And then after the trust is terminated, consider providing some reports to the beneficiaries or other disclosures, again, just to close the loop and show that everything has been done. And remember to work with your tax preparer about preparing a final income tax return for that trust. Again, hopefully that tax preparer has been involved from the beginning to help evaluate the potential advantages and disadvantages of keeping this trust in place. Now, as we talk about advantages and disadvantages, I want to also remind everyone that there might be some alternative ways to solve this issue of this potentially unwanted or unneeded trust. You know, on this podcast, we talk a lot about making sure that the solutions we propose are appropriate for the problem we've identified. So let's say after this analysis, you get to the point where you have concluded this is a problem. You've concluded that this trust, as it currently is structured, is unwanted or unneeded for these reasons, and the costs outweigh the benefits. Well, that doesn't necessarily mean that the solution is to terminate the trust. There could be other ways to address this trust. So, for example, instead of terminating the trust at once and distributing all the assets right away, You could instead ask the trustee to distribute the assets over time, maybe as those assets are needed by beneficiaries. That eventually would terminate the trust, but in the meantime, the assets would be held in the trust and be protected and have the other benefits we've mentioned. You could also think about granting a beneficiary a power upon his or her death over how the assets pass. That could be structured as what's called a general power of appointment, which has some estate tax and income tax benefits. So again, maybe the best solution is not to just terminate the trust, but it's to leave the assets in trust and then give a beneficiary some powers that could have some income tax benefits at the beneficiary's death. You could also think of other ways to modify the trust. We'll probably talk about that in a different episode. But instead of terminating the trust, you could just divide the trust among beneficiaries. You could merge trusts to save some of those administrative costs. Or in fact, if the concern is having a third-party trustee, maybe the solution is to name a beneficiary as a co-trustee or sole trustee in order to have the benefits of the assets in trust, but have the decision-making in the hands of the beneficiary. Now, as we're considering all these implications of potentially modifying or terminating a trust, I really recommend that you keep your legal and tax advisors informed of this from the very beginning, so they can review the potential options for termination, these various benefits and costs, and advise on the best solution. And this is why it's so important for the trustee, the advisors, the practitioner, and all the beneficiary and interested parties to be aware of all these issues from the very beginning. In these episodes, I like to leave with some things for further consideration or sort of a thought experiment. Here, maybe it's pretty simple. If you have one of these irrevocable trusts that is in your constellation of estate planning, then before thinking about just terminating it, maybe evaluate what are the benefits, what are the costs, and are there ways to modify the trust to address some of those issues, or maybe should the trust be terminated altogether? And I think if we can all work together to identify whether this trust is a potential problem in the overall estate plan and what are the appropriate solutions, then everyone can be best served. I'm Steve Murphy, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.